The Senate Judiciary Committee chamber was electric with tension as former Florida Attorney General Pam Bondi took the podium. Cameras flashed. Across from her sat Supreme Court Justice Amy Coney Barrett, calm but alert. "Thank you for this opportunity," Bondi began. "I present evidence that could change everything we thought we knew about Justice Barrett's confirmation." Guess. Bondi lifted a sealed folder marked confidential in bold red. "What I reveal today points to a private arrangement, made before Justice Barrett's hearings, and never disclosed to the public." Barrett's eyes narrowed. Bondi projected the first document, an internal email dated September 18, 2020, 3 days before Barrett's nomination. It referenced a mutual understanding about how certain cases would be handled post-confirmation. Barrett wasn't copied, but the language raised eyebrows. "I never saw this email," Barrett responded evenly. Next, Bondi displayed a calendar entry, a meeting between Barrett and those officials the day after the email. "Routine," the chairman insisted. "Perhaps," Bondi replied, "but this memo isn't." She revealed a summary allegedly written by a meeting participant. It described Barrett's views on upcoming cases and mutual commitments on key issues. Senators shifted. Barrett's face tightened. Then came the note. Handwritten. Barrett's own handwriting. One line. "Maintains an F on PTS 1-3. Barrett examined it. "Yes, that's mine. But it's from my prep notes, confidential client matters, not secret promises." Bondi wasn't done. "I have testimony from someone in that room. Someone who believes what they witnessed broke ethical lines." Barrett's composure faltered. She requested a recess. Outside, headlines blazed. Inside, the foundations of trust were shaking. The recess did little to calm the storm. Inside the hearing room, aides whispered, senators huddled, and cameras rolled nonstop. The stakes had exploded, no longer a routine hearing, but a full-blown crisis. When Justice Barrett returned, her demeanor had shifted. Calm, yes, but with sharpened resolve. "I've reviewed the documents," she began, "and I take these allegations seriously. If there's even a hint of truth, it demands investigation." Gasps rippled through the room. No denial. No outrage. Just control. Pam Bondi, sensing an opportunity, delivered her final blow. "There's one last document," she said, placing it under the projector. A handwritten note. Barrett's script. Legal shorthand. Stars next to case topics. And the phrase again. "Maintains an F on PTS 1-3. Barrett leaned in. "It appears to be mine," she admitted. "But I request to examine the original." She did, carefully. Then turned to the committee. "This was from my personal prep notes. The markings refer to confidential legal work, nothing improper. I can show pages with identical abbreviations." Bondi pushed back. "Convenient," she said. "But what about the whistleblower? Their statement supports that this meeting happened and that ethics lines were crossed." Barrett's tone changed. "Did they take notes during that meeting?" "No, just a recollection that informed the memo." Barrett nodded. "So the memo was written recently, based on 2-year-old memories?" "Yes, but—" "My team reviewed the document's metadata," Barrett cut in. "It was created last month." The room froze. Murmurs turned to a roar. "And," she continued, "on the date this meeting supposedly occurred, I was in Indiana, giving a recorded lecture. The officials I was said to have met with? One was in Florida, the other in Texas." Bondi stood frozen. The facts weren't just inconvenient, they were damning. Senator Cruz seized the moment. "Miss Bondi, do you still stand by these allegations?" Bondi's voice faltered. "I received these in good faith. But, if the timeline doesn't hold, then further investigation is warranted." The air shifted. Barrett hadn't just defended herself, she dismantled the foundation of the entire case. And yet, the battle for truth was far from over. The hearing adjourned in silence, but the storm had only just begun. Justice Barrett exited under tight security, her face composed, yet visibly changed. What had started as a routine oversight session had erupted into a moment of national reckoning. In real time, She had dismantled not just the documents, but the narrative they carried. Pam Bondi remained behind, her once confident posture now stiff. She hadn't just lost control of the hearing, she'd lost the narrative. The same headlines that once framed her as a courageous whistleblower now turned forgery unmasked in Senate hearing. Justice Barrett silences false accusations with facts. Cable news cut to split screens, Bondi's press appearance on one side, Barrett's steady cross-examination on the other. That evening, Bondi made her case to the public. "I shared evidence I believed was credible," she said, her tone more defensive than firm. "If some parts don't hold up, then yes, they should be investigated. But I will not apologize for demanding accountability from our highest court." Critics weren't satisfied. Senators who had rallied behind her were now on the back foot, some even deleting supportive posts. The Senate Judiciary Committee issued a rare bipartisan statement. Regardless of political affiliation, presenting doctored or unverifiable evidence before Congress is unacceptable. We will investigate the source of these materials. Then came the first crack in the whistleblower's story. Investigative journalists unearthed major discrepancies in the individual's resume. They had never held the government role they claimed. Their testimony wasn't backed by records, just fragments, memory, and plausible formatting. It had been enough to fool even seasoned professionals. Still, the damage had a strange aftershock. 2 weeks later, the Supreme Court quietly announced new internal transparency measures. Justices would now document pre-confirmation meetings more thoroughly, with clearer disclosure of potential conflicts. No names were mentioned, but everyone understood why the change had come. Barrett, for her part, issued a short statement. The court's work continues, guided by law, not rumor. Months later, Barrett authored the majority opinion in a landmark case, deciding the exact issue the forged documents had claimed she was pre-committed on. Her vote contradicted the alleged deal. Some saw it as vindication. Others whispered it was damage control. But beyond right or left, guilt or innocence, the hearing had crystallized one thing. In an age of suspicion, even falsehoods can shake institutions. And sometimes only truth, plain, methodical, and patient, can restore what's been broken.